Hello, welcome. I think I'm meant to make some preliminary announcements if I can find my piece of paper. You should turn off your cell phones. You may tweet if you like. The all-important hashtag is hashtag ACS 2017. If you want CLE, consult the people outside. And we'll have questions at the end. I think people will pass around pieces of paper for you to write questions on, and we'll choose the least interesting ones and answer those. The panel today is ambitious, and you have the right people to undertake it. We're going to try to give you a sense of what we know about the Trump administration's national security policy and thinking, and you know, it's a moving target. But we'll see what we can say about it. And let me tell you about who's going to discuss this with us today. Fabulous panel. Moving from my right, we have, and there are more elaborate bios in the materials, so I'm just going to give the briefest of overviews. Raha Walla, who is Director for National Security Advocacy at Human Rights First, a recognized expert in international human rights and humanitarian law, and he's worked on key post-9/11 terrorism counterterrorism policies, and has been quoted in every major media outlet, including the New York Times. Rachel Mirapol is Senior Staff Attorney and Associate Director of Legal Training and Education at the Center for Constitutional Rights, which has been a really early and vigorous supporter of constitutional liberties after 9/11. She's lead counsel in a case called Ziegler against Abbasi, about which we will hear more, both on this panel and I would predict on Monday from the Supreme Court. That's a class action lawsuit against high-level federal officials for post-9/11 detention and abuse of Muslim non-citizens. Rachel has also worked on all manner of litigation in other areas. Steve Vladek is a law professor at the University of Texas at Austin. His teaching and research focuses on federal jurisdiction, constitutional law, and national security law. Every time I turn on CNN, he's saying sensible things about the Supreme Court. Nick Rostow is the Charles Evan Hughes Visiting Professor of Jurisprudence and Government at Colgate University and Senior Research Scholar at Yale Law School. He has obtained every degree that Yale University offers, including a bachelor's degree, a PhD, and a JD. He's served in many senior positions, including as staff director of the Senate Select Committee on Intelligence, special assistant to Presidents Reagan and Bush for National Security Affairs, legal advisor to the National Security Council, and so on. Mary DeRosa is a distinguished visitor from practice and co-director of the Global Law Scholars Program at Georgetown University Law Center. During the Obama administration, she served as deputy assistant and deputy counsel to the president, as National Security Council legal advisor, and in other positions, including as chief counsel for national security for the Senate Judiciary Committee. So as you can see, this is just the right panel of experts to try to take stock of what we've learned so far about the Trump administration's national security policies, and I'm hoping some sense of what kind of resistance, I suppose that's the right word, might be expected from the other branches of the government, from the judiciary, from Congress, and possibly within the executive branch. And I thought we have lots of specific topics to delve into, and we will. But I thought just to get the conversation going, and I've urged all the panelists to make this a conversation, to make it informal, to try to really get to the heart of the issues, not through extended presentations, but through a conversation. I thought I'd just go down the row and ask in a kind of lightning round in just a few sentences on this general topic. What are we seeing in the Trump administration, and what sort of reactions do you think that might give rise to? Raha?
Yeah, so I mean, I think what we're seeing from the Trump administration is definitely a national security policy that reflects the general kind of America First idea, but not in the sense of something that if you talk to kind of Washington policy experts on national security is really something that's going to bolster our national security, but really designed to be transactional and reflect kind of a economic and narrow kind of way of dealing with our foreign policy partners overseas, whether it's cozying up to Russia and other repressive governments, or in the context of counterterrorism strategy, really buckling down on the travel ban. There's a sense out there that Trump campaigned on these things, is here to deliver politically, but has not put into place really the policy frameworks that are designed to really think through these issues in a way that is going to actually help our national security. When we're talking about civil liberties, human rights, I mean, there's a lot to be concerned about. I mean, I think the travel ban is something that we're going to spend more time talking about on this panel, but there doesn't seem to be a reflection that civil liberties, human rights is let alone a primary factor in the policy framework and thinking, a consideration at all. And I think that's really where, from a human rights perspective, we have a lot of concerns, and we'll be focusing our energy in the coming months and years.
So, I think there's two things I'd want to highlight. The first is that because of the fact that there are so many individuals in this country, non-citizens that are here without lawful status at any given time, millions, it's sort of like Trump inherited this loaded gun when he came to power, right? And it's not that mass removals of non-citizens didn't happen under the Bush administration and even more so under the Obama administration. But we're now seeing here under this administration, the complete equation of border security and national security, such that any non-citizen who can be deported should be deported. And what I see that's so different about what happened under the last administration is, that this purposeful spreading of fear in those communities. You speak up at a rally about immigrant rights, you might be arrested and deported. You go to court to enforce a child support payment, you might be arrested and deported. And this is something that, because of the way our immigration law works, it is incredibly difficult to challenge in the court system. It requires community resistance and resistance at the state and local government level. The other thing I'd want to say is that, from my perspective, the biggest threat to national security right now is the escalation of white supremacist violence in this country. It is terrifying, and that's also not something that it's easy to conceive of a way to challenge in a sort of global manner in the court systems. It is too diffuse. And the problem is not just that this administration will not do anything about it, it's that it is complicit in what is occurring, right? Governmental racism facilitates, encourages individual racism and extralegal actions. And that is incredibly troubling from where I sit right now.
Thank you. Steve?
Yeah, I would just say, I think we need to be careful to separate out the immigration piece of this, which I think is where we have seen the most concerted action on what the administration would call national security topics over the first 142 days, right? And everything else, which I think has been characterized by a whole lot of sound and fury and very little movement. So this was an administration that came into office making lots of noise about Guantanamo, right? There have been no new detainees, right? This is an administration that came into office making lots of noise about, ramping up, revisiting, rescaling up our surveillance authorities. All we hear about surveillance is how the campaign was unlawfully surveilled, right? So I think we have a weird dichotomy between the immigration space, where there's lots of very aggressive concerted action that is characterized as national security, and there's debate about how valid that is, and everything else that we would have traditionally thought of national security, where there's been a lot of sort of inertia continuing with the policies of the last administrations, but almost surprisingly nothing in the way of meaningful new policy.
Well, first I want to thank you for having me on this panel. It's a very interesting time. Secondly, I want to observe that I've observed Donald Trump now for some 40 years, because if you live in New York City, it's hard not to. And his MO is to drive people nuts. And so,
Mission accomplished.
thinking rationally about him and his administration is a difficult but a very important thing to do. And when I think about it, when I try to think about it, I come down where Steve did, which is this administration so far is kind of all over the place. And the real question is whether the sound and fury is going to add up to something. I think one needs to remember the movie All the President's Men, follow the money. The administration is going to find out that Congress exists when it deals with money. I was at the annual, as many of you probably were too, the annual meeting of the American Society of International Law in April, and there was a very interesting panel of real live experts on international trade agreements, and one of them quoted a White House official absolutely deadpan saying, "Who knew Congress cared about agriculture?" The president's budget is an opening bid. Congress is not going to accept it. And then the question is, will the president and his agents spend the money, or will they say, we don't need to spend the money, you can appropriate all you want, but we don't have to spend it, which is a major constitutional crisis. So follow the money. The other thing I would say is, write your Congress people and senators. They care about constituent mail.
Just to, I agree with both Steve and Nick's point that we really haven't seen developed foreign policy yet. I do think there are some traits, characteristics of the way the foreign policy is being conducted that give us some hints of how some of the challenges or where it might move. You've got a failure to support allies, a sort of almost a rejection of traditional diplomatic norms. You see that in the budget, the significant lowering of budget for the State Department. You see a almost antagonistic attitude towards human rights in a lot of the interactions coming from the president, the affinity for autocrats and dictators and monsters like Duterte. The interaction with Duterte was just shocking. Sort of tendency to, if Obama did it, we're going to do the opposite, whatever it is, which is, at least to me, doesn't bode well. Rejection of transparency, and maybe I think we might be seeing in the reaction or sort of the glee with which the president was discussing the strikes in Syria and the big bomb in Afghanistan, maybe a tendency to favor the force reaction over others. So I think all of those, give some indication of what we might be seeing in foreign policy.
All right, well, let's drill down on some particular areas, and as Steve suggested, the right place to start, and the most concrete example of the Trump administration's moves in this area is the travel ban. It's reached the Supreme Court. A cert petition has been filed. 2 stay applications have been filed. A response will come from the challengers on Monday, and we may, as soon as next week, have some sort of statement from the Supreme Court, at least on the stay piece of it, which in some ways could resolve the entire case and be a major statement on executive power. I was going to start by asking Steve to just sort of set the table for us. Where are we? What have we learned about the initial travel ban, the revised travel ban, how the courts think about it? What the hell is going on here, Steve?
Okay. So what have we learned? If we go by the president's Twitter account, we've learned that it is in fact a travel ban. We've learned that the first version, that the new version is politically correct and diluted.
Let's pause for a second. What do you make of that term? To call something politically correct suggests what?
That the thing it replaced was not politically correct, and that the politically correct version was adopted for the purpose of appearing to be politically correct. So let me back up. So Adam put the timing exactly right. I mean, the Supreme Court's going to decide, certainly in the next couple of weeks, what to do about these two cases, the one from the Fourth Circuit and the one from some island in the Pacific Ocean. Which, by the way, is not Hawaii. Oahu is the island, but okay. So I think the real question for the Supreme Court is how to deal with the stays, right? Because the executive order is currently on hold. It is subject to two different nationwide injunctions. Whether the court is going to hear the case one way or the other, to me, is much less important than what happens in the interim. And that's why I think the stay applications is where a lot of the work is. Of course, it takes 5 votes to grant a stay, 4 to grant cert. And so I think the question is whether Chief Justice Roberts, Justice Kennedy are of the view that the injunctions should be stayed, meaning the executive order should be allowed to go into effect, pending the Supreme Court's decision to take the case and review it on the merits. And so this is why this is a part of a national security panel, because the government's strongest argument for a stay and to have the executive order go into immediate effect is that every day that goes by without the executive order going into effect hurts and weakens our national security. Now, I think everyone's going to have different views about how convincing they find that argument. I think the real question is, what does John Roberts think? What does Anthony Kennedy think?
But if the order goes into effect, and the order, after all, is just a pause, it's just an opportunity.
A pause that expires on Wednesday, we should say.
So allowing it to go into effect may well effectively resolve the case.
So it may, although, color me as someone who wouldn't be surprised if the Trump administration were to reissue the executive order on a more permanent basis as soon as it sees, a reason to do so. But I think granting the stay is tantamount to ruling for the government on the merits anyway, because it would require accepting the national security justification to allow the executive order to go into effect now, that I think would really go a long way toward resolving the case on the merits, right? I don't think the flip side is true. I don't think it's true that if the court denies a stay, that means that there's no chance for the administration on the merits. But I think this is why I think the stay is the ballgame in one direction, because if the court grants a stay, it means they're actually accepting the national security arguments that I think have been so thoroughly criticized in at least some circles.
Let me see if there are thoughts from other members of the panel on this question. There are many people who say that on its face, particularly the revised executive order, is perfectly lawful, and what makes it unlawful is what we know about President Trump's motives. And looking behind the 4 corners of the document and looking at the motives makes it unconstitutional, makes it a violation of the Establishment Clause. And several courts have said that, and some of them, like the Fourth Circuit, divided strictly along ideological lines, 10-3. Do you see in this an initial take on how the courts might be pushing back against the Trump administration?
Yeah, what's most interesting, I think, about the question of how the courts should consider candidate Trump's statements about the travel ban when he called it a Muslim ban, right, is that, it seems logically that of course you consider statements like that. Why in the world wouldn't you? The reason, perhaps, why this is a controversial move in the courts is that it's so rare to have a candidate so explicitly speak about doing something that, from my perspective, is so blatantly unconstitutional, and then to come into power and actually do that thing, right? The thing that's so hard about proving or even stating a religious discrimination claim in the federal court system is that you have to be able to put forward that, an allegation of an invidious motive of discrimination based on race. It's not enough just to impact people differently, right? And we have that here. It's something we don't normally have. But now that we have that, we have this question of, can you even consider it? Of course you consider it. Why in the world wouldn't you?
I would draw a distinction between. I'm sorry, Nick, please.
Yeah, no, I think, first of all, the courts, as a general matter, will defer to the president on questions of national security, and they don't like to get in there and second guess the president. So at the level of the Supreme Court, I would say the administration on this executive order, the revised executive order, has a chance. The question is whether the court will read beyond that. Mary and I served at the NSC. We dealt with national security problems all the time and legal problems, and if such a travel ban was important to enhancing the national security of the United States, it would have been adopted a long time ago. It is not that easy to get into this country, and it's not that easy if you're applying for a visa anymore to get in. And it's not self-evident to me that the national security argument has any credibility, but the courts will defer to the president on this point. So it's a question of whether there's ancillary things. And I would remind you all that in the Reagan administration, when they cooked up the famous case of INS against Chadha, everybody was under a order not to say a word about that case as it made its way to the Supreme Court, because they didn't want, they were challenging the one-house veto and the non-presentment of bills to the president, and they didn't want to say anything that might derail that case. And this administration, of course, doesn't have that discipline.
I'll just add to that. I mean, I think it's clearly true that courts tend to defer. They're uncomfortable with getting in the middle of issues that involve national security and in that kind of decision making. What I think is interesting. I mean, judges sort of live in the world, and I think what maybe we're seeing, and I'm hoping we'll continue to see, is the judges reacting to a complete lack of serious deliberation about national security issues, and of course all of the statements they would have to ignore ignore some really obvious things to step back and defer to the president here. I think they're a lot less likely to do that.
I mean, Adam, you asked if courts are treating President Trump differently.
Yes.
And I would just tweak the question a bit to say, are courts treating President Trump differently than they would treat a different president who did the exact same thing? Mm-hmm. And the reason why the exact same thing piece of that matters is because there's been a lot of hay made out of the concession by the lawyers for the challengers in the Fourth Circuit that if President Obama had promulgated the second executive order, it would be upheld. Well, yes, if President Obama had promulgated the second executive order without any of the anti-Muslim rhetoric, without any of the anti-Muslim statements, without any of the substantial baggage that the second executive order in this context comes with, I agree. But I don't know how, let's keep in mind, right? If President Obama had instead said, no, I'm anti-Muslim, I'm proving to you, President Trump, that I'm not from Kenya, right? I think we're taking that concession out of context, right? Because I think the question is not would another president have had this executive order struck down. It's would another president who had said all of the ridiculous things President Trump has said nevertheless survive this case.
Right. So in the administration's cert petition, I thought there was a reasonably powerful point saying campaign statements, at least, can't be taken account of. Those are off the cuff, hyperbolic, before the weight of the inaugural oath is taken, weighed down, turned President Trump into a serious man who's formed a government, taken advice from high-level officials. And if it's true that the campaign statements will haunt him forever, is he permanently disabled from ever issuing an executive order in this area, even 3.5 years into his administration? And I thought those arguments had force. And then moments later, he started tweeting and seeming to echo some of the earlier points. But absent the tweets, is there not something to be said for a campaign statement is different in kind from a formal statement from the United States government?
that to me?
Yes. I mean, otherwise we'd be indicting people for bribing the electorate with campaign promises, as A.P. Thornton wrote in a funny short story 75 years ago. It's just not, it's not the same. But this president needs to learn that he's president 24 hours a day.
I think it's hard to generalize. I mean, Kate Shaw, right, has a really interesting forthcoming article in the Texas Law Review and an op-ed in the New York Times from last week about when you should and shouldn't take presidential speech seriously, or literally, or both. I guess I think it's right that a president should not be forever precluded from having a compelling national security reason for taking action against a group who has previously expressed some kind of bias against. I'm just not sure this is the case to test that theory. I mean, Judge Thacker's concurrence in the Fourth Circuit went out of its way to show how, even if you just look at what the president has said since January 20th, there's still a pretty compelling case, and that was before the latest tweet storm, right? And you know, if the question is about motive, of course, if you guys study any anti-discrimination law, you can always dissipate taint over time if there are actions taken to suggest that, you know, the underlying bias is passed. It's a relevance question. It's how much weight do you give it, not should it matter at all.
And just to add, I mean, I think that if over the course of, you know, the 3.5 years, there was a process that, a decision-making process that led to something like this, you know, sort of bottom up, I think that would be more persuasive to the courts, and the courts might look at it different. I mean, I'm not saying they would then uphold it, but I think that is an important part of why that they're really not, you know, that they are so skeptical of this order, is because there are campaign statements and presidential statements, but also there's really nothing else supporting this order to explain how they've gotten there.
I mean, the last thing I'll say about this is just that, you know, I mean, this was one of the first official acts, right? I mean, it is inextricably tied to the campaign in that sense that this was designed to deliver on a campaign promise without that sort of rigorous interagency process to determine whether, in fact, this order was necessary to protect our national security. And it's worth noting, you know, although courts do definitely defer to the executive on claims of national security, I mean, that deference isn't unlimited, right? And you'd have to think, at minimum, judges, you know, being citizens of the United States and aware of you know, just generally what's going on, would recognize that, you know, even in the immediate aftermath of 9/11, nothing even close to this drastic was implemented. You know, there is very little evidence that there are threats of terrorism, at least in terms of non-citizens coming from these particular countries, that are subject to the ban. You know, almost the entire national security establishment, including a lot of people with former government experience, immigration experience, counterterrorism experience, both sides of the aisle, have spoken out quite strongly against this ban as something that not only doesn't, you know, protect our national security, but could have deleterious effects on our national security. So these are just facts of the world that we live in, and, you know, it strikes me that, you know, judges will pay some attention, you know, to the weight of these national security arguments.
I don't think they will. I don't buy it. I think I don't buy the process argument that the president has to make decisions through a process. As Lyndon Johnson once famously said, the president can take advice from his chauffeur, and there's not a damn thing Congress can do about it. The president is accountable politically, remember your Marbury against Madison, for an awful lot of things, not legally. And the president decides what's the national security requires or not in such an instance. The trouble is this president's made it murky as to whether he's really defending the national security and that's what's motivating him, or something else. But whether or not the decision was made with the advice of his most senior wise men, if he has any, is a matter that's, I think, judicially irrelevant, and certainly the Supreme Court won't pay the slightest bit of attention to.
But I do agree with Mary that, you know, the closeness in time between these statements and implementation and the first executive order and then the revised executive order, that matters to that question of whether the court's going to look at those statements. And, you know, the argument in the cert petition that, you know, the fact that the ban was reissued shows the president's good faith just struck me as so discordant. I mean, civil litigators deal with this all the time. Whenever you have the smallest victory in challenging a certain policy, it gets changed just enough to try to derail the progress that's been made, but to accomplish the same thing. So I see that just as hiding the ball completely. And look at that really, you know, it might be different if we could imagine a scenario where we had a president who learned from his mistakes and could acknowledge mistakes, but obviously that's been shown to not be the case here. The change can't really be taken as indicative of any attempt to cure constitutional deficiencies. It's an attempt to hide them.
So let me ask one more travel ban question. A lot of good normative and strategic analysis, but it would aid me in my work to know what's the Supreme Court going to do? Anyone care to? I guess we'll find out soon enough.
Wait and see.
All right, let's move to a second topic. You know, I'm a journalist, and therefore I'm entirely in favor of leaks. But I think there are people in the government who thinks that leaks can be a problem. The Obama administration launched more leak prosecutions than all previous administrations combined. The Trump administration's a little slow out of the box, but this last week did launch its first prosecution. President Trump has accused his former FBI director of being a leaker. So I guess we may, in the process of this discussion, try to nail down what we mean by leak. But I was hoping, Mary, you might give us some reflections on what's the right way to think about leaks, what ought the government be doing to address them, and what role do they play in civic discourse and in democracy?
Okay, well, I think I tend to be kind of hardline, particularly on classified leaks of classified information. I think maybe more hardline than certainly than you.
Probably.
And I mean, I also admit to having having a hardline view, but it is the implications of my view on this are causing me great angst and in the past few months because there have been a tremendous number of leaks. A lot of the information that's out there, I'm not sorry is out there, but I think the leaks it's extraordinarily dangerous, particularly national security leaks. I will say I'm going to distinguish here national security classified information and to some degree national security decision making. If people want to leak about who's in and who's out in the White House and that sort of thing, I don't particularly respect it, but I certainly don't.
What the president said to them.
Yeah, that's right. I mean,
hypothetically.
I don't lose any sleep over that. But when you're talking about specifically leaks of classified information, start with that. This is sort of an obvious point, but I think it's often, the costs are often downplayed. With something, and yes, things are overclassified, and that can be the case, but if you have a leak of a communication that's been intercepted, and that's out there, well, somebody now knows that they're being, the fact that these people are being intercepted is now known. If you have a leak about a classified program, about a covert action, about capabilities of, a particular country, you are giving something away that is important to national security, and that is harmful. And I understand the reasons. But I think the costs of it are downplayed. On national security leaks of decision making, whether classified or not classified, I think it's a more subtle point, but to me, a very, very important point. And that is that national security decision-making this is hard stuff, this is important stuff, and it's so critical that you have as much input and into decision-making from different areas of expertise, people with different perspective, different agencies, et cetera, into decision-making process. When you have a lot of leaks of national security information, the reaction of the decision makers is to narrow the circle and tighten and let fewer people in, and so you're losing the input, the critical input and different perspectives into national security decision making, and that is harmful. And I've seen it to some degree. I think as I said, the explosion of leaks in this administration, during this administration, it's got to be having that effect, and it makes me, I find it very troubling.
I agree with Mary, I would say about 99% of the way. I think what's very important to protect are what we know and how we know it. And a good example of the consequences of revealing publicly how we know things is President Reagan's famous announcement in 1986 that the United States had intercepted a phone call between Libya and people in Berlin who had bombed a disco frequented by American soldiers. And the result was a bombing raid on Libya. The second result was the Libyans stopped using telephones. So that cost is real. Where I'm not sure that I would agree, and I totally agree that there's no doubt that leaks can have a chilling effect on the decision-making process and the interagency process, but more importantly, prosecutions have a chilling effect. So fear of special prosecutors, fear of anything that you say, any note you take might be the subject of a subpoena, is even more detrimental to rational government, or as Colin Powell used to say, getting people's pet rocks cast aside in the interests of good government. But it's a tricky balance, because without leaks, it's hard to have a democracy.
I'm curious if either of you think that sort of the way we analyze leaks has to be understood in the context of overclassification of information. Increasingly hostile reactions to Freedom of Information Act requests, attacks on independent journalism, right? So it's not just that leaks occur in this vacuum where we have a set stage for what the government discloses and what they don't. It feels like that, that world is tightening in, and that leaks are perhaps a reaction.
Yeah, completely agree, and I would say that is part of the source of my angst and self-doubt that I have on these issues, because there are, why are there leaks? So there are all sorts of reasons, but a lack of, the public deserves to understand what is going on in the government and what is motivating the government, and a lack of transparency. Always a problem in the national security world, but I think even more of a problem when you've got an administration and a president that's not just not transparent, but saying things that aren't true. And so you've got people who are in the bureaucracy, or who know that what's been said is wrong, or that important things aren't out there, and they're going to leak. And absolutely, that contributes. It is to some degree, this administration in particular, and administrations in general, probably bring it on themselves. But it's still, extraordinarily harmful.
I mean, I would add to Rachel's point, though. It's not just about an administration that is incredibly hostile to transparency. It is also about a breakdown in what historically had been at least a relatively powerful mechanism for accountability and transparency. And let me be for the first time, but not the last one on this panel, let me say, let's not absolve Congress of responsibility here. So, next Thursday, I hope you guys are all planning a birthday party. The Espionage Act turns 100, right? I mention that just because 1950 is the last time Congress revised the Espionage Act. This is the statute, the only one that actually criminalizes unauthorized disclosures of national security information, and doesn't even refer to classified information because it's older than the term classified information. Congress has considered on, I think, about 14 occasions since 1950 revising the Espionage Act to actually try to answer some of these questions. With the advent of modern technology, with concerns about reporters' privilege, with all of these things. And the answer every time is it's too hard. And so, I think we have to be careful here to sort of not let Congress off the hook for abdicating any responsibility for what really is a very complicated, messy public policy conversation.
Excellent. Next topic, and now we're moving into areas where we don't know very much about where the Trump administration is going. I want to ask Raha about where we are on Guantanamo Bay, military commissions, torture, these issues that in the Bush administration, the Obama administration, so much engaged us, and I really don't have any clarity on where the Trump administration is.
Yeah, I mean, I think this is back to the category, that Steve described in his opening remarks of areas in which, there has not been a lot of movement policy-wise, but there's a lot of concern about potential for movement in various directions that, from my perspective, would be quite destructive. On Guantanamo, Trump, famously said in the campaign, I'm going to fill Guantanamo up with some bad dudes, and there hasn't been anyone who's moved to Guantanamo, under the Trump administration yet. We should talk about, I think, why that's the case. I think it's just a really hard legal and policy problem. It's not as easy as just picking up a terrorism suspect and transferring them to Guantanamo. But there are 41 detainees at Guantanamo. There are a few, I think, interesting policy markers that you should watch for. One is 5 of those detainees are cleared through the interagency process for transfer out of Guantanamo. It'll be really interesting and important to watch the Trump administration as they make a decision or don't make a decision to transfer those detainees that the intelligence, law enforcement, military agencies and departments have unanimously agreed should be transferred out of Guantanamo. And you can have a debate about whether Guantanamo should be open or closed, but I think everyone agrees that if you're going to hold people, you need to have a mechanism in place, to evaluate whether they should at some point in time be transferred. There is an administrative mechanism. It's called a periodic review board. This was implemented under Obama. It had a lot of bipartisan support. It's the interagency process to review detainees. That's another area to watch. Is the Trump administration going to continue those administrative reviews, or is it going to take active measures to undermine them or somehow change the process in a way that will be less friendly from a due process or detainee rights perspective? And then, of course, is the Obama administration, going to take steps to transfer detainees to Guantanamo? There were actually 2 leaked executive orders, draft executive orders. One that combined kind of Guantanamo and interrogation issues. It got a lot of. It actually got rebuke from Republican members of Congress in addition to Democrats. I think from this sense that the Trump administration was moving quickly and not really thinking through these issues. So, I am expecting at some point in time some sort of an official kind of policy statement or action from the Trump administration that will at least make a nod towards continued use of Guantanamo. I think the real interesting question is, what will the scope of that use be? How much are they going to use military commissions versus federal courts? And I think watching that is going to be really important. Just briefly on torture, this is an area where you've had a wholesale reversal where President Trump said he wanted to use waterboarding and worse. That's a direct quote. That terrorism suspects, even if torture doesn't work, terrorism suspects deserve it. Just all kinds of really frankly terrible and uneducated statements in the campaign. But then, as the nomination process moved forward, for Secretary Mattis and a number of other top officials in the Trump administration, you had near unanimous agreement from now cabinet level officials that these kinds of actions are unlawful and inappropriate and unwise. And this includes individuals who had not been so great on these issues in the past. And I think that is really a testament to the idea of where the campaign rhetoric kind of hits the policy reality of what it actually takes to govern, and especially on these important national security issues.
I've actually been to Guantanamo, so
It's hot.
if you have to go to jail, go to Guantanamo. It's much better than any other place I can think of. You've got 2,000 people
Disagree.
keeping 40 people. No, I'm serious. You've got 2,000 people making sure 40 people are healthy, wealthy, and wise, and doing what they want to do.
I'm not sure that the rectal force feeding is really consistent with that.
It's not
view.
rectal force feeding. I've observed an extraction and force feeding the whole bit. It's by far more pleasant than Attica, than the tombs in New York City, than Washington, D.C.
Well, it certainly raises the question that people...
No, but that isn't my point. The point is, we don't take prisoners anymore. And that's because of the controversies over detention. So just think about that for a minute. We don't take prisoners. We kill them. And that's been the policy for, I don't know, where are we, 2017? 15 years?
Mary?
So, I've heard that so many times. I just have to say, in my experience, it's not true. It is not true that the policy is don't take detainees because it's too controversial.
It's not
It's
may
not.
not be
And
policy, but it's what happens.
Well, but it happened, true, a lot fewer detainees now or in the last 10 years than before that. But, it's sort of, there was the low-hanging fruit. I don't know if that's an appropriate way to talk about it. There were a lot of people in the situation in Afghanistan and right after 9/11. There were a lot of people to get. Now you have a much more complicated situation with where the troublesome people are and how easy it is to get them and how dangerous it is for U.S. personnel forces to go in and grab these people. And those are the reasons that you have fewer detainees.
But so is there a disagreement between the two of you? Or maybe it's
I
policy,
think,
Yes.
I think that there is a disagreement about the reason.
Yeah, I would add a third factor, which is, Mary's exactly right that the nature of the U.S. military operation has changed in ways that really impact the problem. We don't have massive ground operations that are rounding up dozens and dozens of suspects at one time. But let's also not forget two other pieces of this, right? First and most importantly, there's the problem of proxy detention, right? Which is that the United States, we know, has and continues to have various degrees of agreements with a lot of our partners and allies overseas to hold at least some detainees, whether on our behalf or at least with our cooperation, right? And so 41 is not the sum total of terrorism suspects who are in some kind of military-like detention. Those are the total who are in actual U.S. custody. But second, I think part of why it was so problematic as a policy matter to look at ISIS, for example, and ISIS detainees as the next source of potential folks to bring to Guantanamo is, I think one of the most important questions of contemporary national security law involves whether the 2001 authorization for the use of military force extends to ISIS. The administration, both the Obama administration and now the Trump administration, has been successful so far in avoiding having to litigate that question. And the second that an ISIS detainee is sent to Guantanamo, that becomes a justiciable question, the answer to which might not be what the government wants it to be. So I think there's a complexity here that resists a simple, we don't have any more detainees because we just killed them all.
And just a two-finger on that. I think part of this is, defining the problem down in a way that's not necessarily helpful. We have moved a number of terrorism suspects into federal court prosecutions in the United States. Dozens and dozens of those have been individuals who have been captured overseas in very difficult contexts and environments. Why? I think that's because it is legally a lot easier to do it that way than it is to transfer an individual to Guantanamo or put them in prolonged, indefinite military detention, where you have these kinds of legal issues where many of our allies have actually said that they will refuse to either provide intelligence or access to terrorism suspects if the result is going to be military detention or military trial at Guantanamo. They just don't agree that Guantanamo is a lawful or appropriate venue for detaining individuals. So I think that is also something that needs to be focused on, which is that we do have an effective, legally available option to deal with terrorism suspects in our federal courts in the United States.
And so this might, take us in a little bit of a different direction, but I can't leave Nick's statement hanging out there, right? Which is that, it may be that conditions at Guantanamo have improved in recent years from the times that, individuals were being tortured there. But the reason why we see a situation where you have detainees hunger striking for years on end till they're 80 pounds is because Guantanamo is different from any other federal jail in that you go there without charges and you may never be released even if you are cleared. And that creates a situation where men might actually consider dying to get out. And I think that it is very dangerous for us to feel relief at the idea that that Guantanamo hasn't gotten worse necessarily under this president, because what we already had was so bad and we can't forget it. And just the fact that it was going on under the Bush administration and the Obama administration and now under this one cannot justify forgetting the 41 men who are still there and who may be there forever. Witness Against Torture actually has a campaign going on right now called 41 Days, which, every day they're highlighting the story of a different human being who is at Guantanamo, perhaps indefinitely. And I would encourage you all to look at it. And they asked the question by this poet, Luke Nephew, are we going to pretend they're less than men and turn away? And we can't do that just because this president is so much scarier in so many ways. We have to recognize the continuing human and civil rights violation that has been occurring there for 15 years.
Nick? Yeah, The whole Guantanamo thing, and I was being perhaps a little flip in saying that it's a nice prison as prisons go, but I think it probably is. I have written on this subject quite a bit, and it's worth explaining a little bit how the government's knickers got in a knot. And it's a cautionary tale to everybody. The reason the government got off on the wrong foot was a memorandum from Alberto Gonzalez to President Bush, which said that when interrogating detainees, the only thing you can ask a prisoner of war under the Geneva Conventions is name, rank, and serial number. And that was an error. And of course, the president's immediate reaction, what good is that? First of all, these people don't have names, but they don't have ranks and serial numbers. And secondly, that's too limited. In fact, under the Geneva Conventions, you can ask a prisoner anything. They're only required to give you a name, rank, and serial number. But that error led to the Bush administration's dissing of the Geneva Conventions. And I have argued that as a matter of policy, we should treat all the detainees as if they were POWs under the Geneva Conventions. Why? A, it allows you to detain them indefinitely, basically until the end of the conflict. B, if you have evidence that they've committed crimes, you can charge them for those crimes. If they're tried and convicted, they can serve their sentences and then go back to being POWs. If they're acquitted, they go back to being POWs. So you stay within the rule of law, which I think is so very important, and the real problem I have with Guantanamo is that it's been in this legal black hole, which is in my view, a terrible place for the United States to be in. And it goes back to this initial memorandum, which contained this fatal error. And but for a nail, the shoe and everything else was lost.
So I would just say, I think the error was not just a mischaracterization of the Geneva Conventions. I think the error was thinking that intelligence was the most important consideration, and gathering intelligence was the overriding uber thing to worry about, and that everything else could be sort of lawyered into oblivion. But whatever I don't think we're here to relitigate how we got here. With regard to going forward, Raha, I think, gave a really great overview of the detainee piece of this. Let's not forget the military commission piece of this. The commissions are still there. I once described them as cockroaches, right? That after the nuclear war, the military commissions will still be going. Right? We're 15 years in, right? They've convicted 8 detainees in 15 years. 4 of those convictions have already been vacated because of jurisdictional problems. Appeals are pending in 2 of them. There are 3 pending trials, 2 of which have their own jurisdictional issues, the 3rd of which is the 9/11 trial. And so there's actually we're at a pretty important moment in the sort of past legitimacy and future utility of the military commissions, because the Supreme Court, for the first time since 2006, is now being asked to weigh back in on the constitutionality of how these trials are being conducted and the constitutionality of their jurisdiction. There are now cert petitions pending in 2 cases that the court will consider, I imagine, at its long conference in September. I don't think the court has to take these cases, but if the court is interested in weighing back in, now could be a very important moment for it to do so.
Let's talk about a couple other cases that are before the court and that will be decided shortly unless they go for, unless one of them goes 4-4, the other one has only 6 justices. Let's talk.
3-3.
Let's talk about the 6th justice case, which Rachel argued very ably, and which, as I mentioned earlier, will come down very shortly. It's an effort to hold Bush administration officials accountable for post-9/11 abuses. Tell us a little bit about the case, Rachel.
Sure, and please do interrupt me if I go on too long. It's hard for me to talk about the case quickly because it is long. This is a class action. Ziegler v. Abbasi is a class action that the Center for Constitutional Rights filed in 2002 on behalf of Muslim, Arab, and South Asian men swept up after 9/11. So, tips are coming into the FBI hotline right after 9/11 with all sorts of reports of Muslim men acting suspiciously by renting apartments or using the post office or working, and literally. FBI director then, Robert Mueller, now special counsel, of course, ordered that all of these tips be investigated, even those based on pure animus or profiling. And then Attorney General John Ashcroft ordered that everyone arrested as a result of that investigation, everyone found to have violated the immigration law, working unlawfully here without a visa, be arrested and held in connection to the terrorism investigation until they were cleared of any connection to terrorism and then deported. Ashcroft met with a small group of officials in Washington to sort of map out ways to exert pressure on the hundreds of men arrested in those sweeps, while knowing that there was no actual basis to believe the men were connected to terrorism. There was merely the fact that they were arrested as a result of one of these tips. So the Center for Constitutional Rights filed suit, arguing, among many other things, that for the 100 or so detainees who ended up being held in a federal detention center in Brooklyn called the Metropolitan Detention Center, these men were placed in solitary confinement there. They were treated as if they were actually dangerous. They were beaten, they were harassed by guards systematically, not just one-offs. They were kept from practicing their religion, kept from contacting the outside world. Incidentally, it's reported that Ashcroft actually ordered his subordinates, let's make sure they can't get Johnny Cochran on the phone. This is about making sure these detainees are controlled and can be pressured to lead to evidence of sort of ties to terrorism and to lead to other terrorism suspects. So we argued that that violates equal protection and due process. And, after many procedural twists and turns, which I will not bore you all with, the case is now 15 years later in the Supreme Court with 3 discrete legal questions on the table. The first is, can civil rights plaintiffs sue federal officials for damages when they violate their constitutional rights? Second, did the plaintiffs in this case plausibly plead that the defendants at issue were responsible for violating their rights? And then third, is it actually clear that it's unconstitutional when you have a group of individuals arrested in connection to a terrorism investigation to put them in the most restrictive conditions of confinement in the federal system, when there's no individualized basis for suspecting them, when you're rather looking at race, religion, and ethnicity? So I'll talk about the first question because I think it's probably the most important for sort of where we sit right now. Unlike for state officials, there's not a statute out there that allows individuals to sue federal officials for damages when they violate the Constitution. Instead, in 1971, the Supreme Court decided in Bivens v. 6 unknown named agents of the Federal Bureau of Narcotics that the victim of a warrantless home search could sue for damages directly under the Fourth Amendment, could sue the agents that were responsible for that search. And the Bivens doctrine has been used to allow individuals to sue federal officials for damages for various discrimination and abuse since. What the government is now arguing in Ziegler is that the court should not allow these kind of implied constitutional actions in the areas of national security and immigration. That federal officials who create government policy that touches on those areas cannot be held personally accountable when they violate the Constitution. And I think what's so remarkable about this argument is the way it interacts with the doctrine of qualified immunity, which already protects all government actors, state and federal, who act in good faith, but nevertheless violate the Constitution. Under qualified immunity, government actors can only be held accountable personally accountable for constitutional violations if they violate clearly established law that any reasonable officer should have known about, right? So that means what the government is arguing here is that our highest federal officials, the Attorney General of the United States, the Director of the FBI, can create government policy that violates clearly established law and will not be held personally accountable. I think, some might ask, and the Chief Justice basically asked this at argument, why do you need a damage action here? Why isn't the fact that you can sue to stop unconstitutional actions when they're occurring enough? And we see this in the travel ban cases, right? That got stopped in its tracks. I think there's two reasons why preserving a Bivens action is so important. And that's because the victims of civil rights violations can't always get into court immediately while a violation is occurring. If they don't sue while it's happening, the only way to get judicial review of the action is a damage action. And that means that some types of government abuses could be completely insulated from judicial review. The second thing is that a case for injunctive relief doesn't deter future illegality, right? And we can see that so clearly with this administration. The Supreme Court has held again and again that damage actions deter future illegality. They're not just about compensating the victims of that illegality. And if there is nothing to sort of deter those constitutional abuses from occurring in the future, well then, as Justice Breyer said during argument, beware of, I don't want to misquote him. He said, beware of cutting off Bivens. You never know what will happen, right? And that was 2 days before inauguration. So I think, we're all thinking the same thing. You never know what'll happen.
You were arguing to a 6-member court. Does that make your job a little harder?
Well, yes. Justices Sotomayor and Kagan are recused in the case, right? So you can all do the math. It's a difficult time, I think, for this case to be up at the Supreme Court with this math. One of sort of the government's defenses here is that, faced with a group of men that shared the same racial and religious and ethnic identity as the 9/11 hijackers, you could excuse government officials for treating them all as dangerous because it couldn't immediately sort out who was just a civil immigration violator and who was actually a terrorist. And what's so troubling about that argument is that it is actually exactly the same reasoning that the Supreme Court accepted in Korematsu, a case that has not yet explicitly been overruled. There the Supreme Court said, we can't second guess the military determination that the military could not immediately separate the disloyal from the loyal. And that's why Japanese internment wasn't about discrimination, but was about national security. We don't want the court on Monday or the following Monday to send the message to this administration that non-citizens, Muslims here in the United States, can be presumed dangerous until they're proven not.
So this case is 15 years old. That suggests that if someone sues a Trump administration official today, we might get an answer in 2032?
Yeah, well, if you're trying to get damages, it's going to be a long road. That's absolutely true.
Let me ask Steve quickly to talk about a case he's involved in, also has Bivens issues and heartbreaking facts.
Yeah, so they were granted on the same day. So Hernandez versus Mesa, I'm co-counsel of the petitioners, so no one had to watch me argue, which was good. So Hernandez is a cross-border shooting case where you had a Customs and Border Patrol agent who, at least based on the facts as alleged in the complaint, without any provocation, fired across the U.S.-Mexico border and shot and killed a unarmed 15-year-old Mexican national. And what's interesting about the Hernandez case from a sort of Supreme Court optics perspective is in the Fifth Circuit, in a unanimous en banc decision, had relied on qualified immunity, had held that Hernandez, as a Mexican national without prior substantial connections to the United States, it wasn't clear that he had constitutional rights that Agent Mesa could have violated. There are lots of ways to quibble with that holding, but it didn't really jump out as being especially cert-worthy. And the Supreme Court granted cert and added the Bivens question, which is whether in that context, someone like Hernandez's family could bring a Bivens action against Agent Mesa for a violation of the Fourth Amendment, and they added it the same day they granted Rachel's case. So, I think the working theory is that the court realizes that they need to say something one way or the other about what had been a pretty alarming trend of lower court decisions, recognizing new and more categorical exceptions to Bivens in national security cases. The government has argued that Hernandez is a national security case, right? A 15-year-old Mexican national playing with friends on the Mexican side of the U.S. border. That's an important proposition if the Supreme Court accepts it. And I think what's going to be interesting to see is how Rachel's case and Hernandez come down together, right? Does the court try to sort of split the difference and not kill Bivens, but create sort of special rules for national security cases? Do they look at who the defendants are so that a line officer, Border Patrol agent, can be sued, right? But perhaps a senior government official can't be? Justice Kennedy alluded to that a bit in his concurring opinion in the Al-Kid case in 2011. So, I think it's going to be fascinating to see what happens there. I think it's going to have huge implications for national security. But I would go farther. I think Bivens is perhaps the most important not understood doctrine, right, when it comes to constitutional law and accountability. And I think that there's been way too much ability on the part of the courts in the last 10, 15 years to cut back on Bivens without it actually producing any kind of response, whether from the legal academy or from progressive institutions, or dare I say from Congress, right? And so we'll see what happens.
So can I ask just a question? When did this shooting take place?
2010.
Wow. Why didn't the government make an ex gratia payment to the family?
They didn't offer to. I can't tell you why. But let me just say really quickly, Hernandez is not a unique case. There have been at least 6 fatal cross-border shootings involving Customs and Border Patrol agents over the last 10 years. There had not been an indictment of any of these officers until the cert petition was filed in Hernandez, at which point the officer in a California case was indicted for murder. So this is not just a one-off officer who had a bad day, right? This is actually a pattern of accountability gaps. that we're worried about.
Steve, you say that one difference between the cases is who is the defendant. Is another difference in the case who is the plaintiff?
Yes.
Because I guess it's at least an open question whether a foreign national or the grieving parents of the dead foreign national can come into American courts to assert these rights.
Sure. I mean, so Hernandez, Abbasi has three issues, right? Pleading, qualified immunity, and Bivens. So we also have three issues. We have the merits, Bivens and qualified immunity. And the merits question is whether a Mexican national standing just across the U.S. border is protected by the Fourth Amendment. If you guys know your sort of criminal procedure jurisprudence, there's actually a really fascinating tension between Chief Justice Rehnquist's majority opinion in the Verdugo-Urquidez case in 1990 and Justice Kennedy's concurrence about whether the border is a formal on-off switch when it comes to Fourth Amendment rights for non-citizens, or whether courts should apply a more functional approach. And if the court is willing to recognize in Hernandez a Bivens cause of action and to hold that Agent Mesa, on the facts as alleged in the complaint, wasn't entitled to qualified immunity, then Adam will have to reach the Kennedy question of whether we actually apply more of a functional analysis. Adam, obviously that has pretty important implications for national security if there are going to be more context besides just Boumediene and Guantanamo habeas cases where any aspects of the Constitution are applied to non-citizens overseas.
Well, it would be helpful if the court would issue them on the same day, because then I could write about them in the same story.
I'll see what I can do.
If you, any arrangements that could be made would be.
I mean, they
quite
granted
helpful.
them on the same day. Right? They were originally supposed to be argued on the same day. I mean, it's clear that they see them as being of a piece.
All right, I got a bunch of excellent questions here, so we're going to turn to questions, and then maybe we'll do a little thematic wrap-up at the end. Let's see how it goes. This is a good question, apropos Guantanamo. What do we do with released detainees, especially if they can't go home? Obviously, it says in parentheses, perhaps obviously, perhaps not, obviously can't come to U.S. So we've talked about some people who are cleared to go. The Obama administration wasn't able to place all of them. Is it plain that they shouldn't come to the U.S.?
No, I mean, I think, if we're talking about released detainees, I mean, this was a big problem early on, in fact, where you may or may not recall this, but there was a plan to relocate a number of cleared detainees, a group of Uyghur detainees, actually, who the government had readily admitted posed no national security threat to the United States. Then Congressman Frank Wolf from Northern Virginia got wind of this, raised a ruckus, and it caused a whole firestorm on Capitol Hill about terrorism suspects being relocated to the United States, which prompted legislation, and the rest is history. But I think that in a rational world where you have individuals who have essentially been cleared of all wrongdoing, there should be an option for relocating to the United States. That is now statutorily barred by the National Defense Authorization Act. So there is a prohibition on transferring detainees to the United States, which only leaves the ability to transfer detainees either to their home country or to a third country as a resettlement option if transfer to their home country is not available.
A travel ban question. I'm very uncomfortable with the travel ban, the questioner says on the one hand. I'm also uncomfortable with the Supreme Court determining the legitimacy of a president's motives for national security decisions. Is there a narrow position the Supreme Court could take to satisfy my concerns? Are there off-ramps? And there certainly are, and I think they're fairly likely.
Yeah, I mean, I think there are at least three. So off-ramp number one is mootness. There are four. Off-ramp number one is to deny cert and just to sort of pretend they never heard about it. I think that's unlikely. I mean, the government since 9/11 has asked the Supreme Court to grant cert in 9 national security cases. It probably won't shock you that they're batting 1,000, right? That the court has always granted.
Yeah, so I mean, and this may step on one of the points you're about to make, but I could imagine a denial of cert accompanied by a statement from, say, the Chief Justice saying, you don't read anything to this, we're denying this in light of the fact that
it's moot. Yeah. Right. No. So you could totally get, like as in the Jose Padilla case back in 2006, a cert denial with a 3-4 justice concurrence saying, we're not expressing any view on the merits. You could even get what's called a Munsingware order, right, which is a vacatur of the decision below.
I'm looking forward to explaining that to my readers.
Indeed. But I actually think that's not likely, because I think if there's any real indication of that, you have if ever there was a policy that was capable of repetition yet evading review, where you could reissue the executive order. The other off-ramps are statutory. So the other off-ramps are to hold that the president didn't have the statutory authority, or that in some context, pieces of the executive order violated a statutory constraint on the ability to discriminate on the basis of national origin. I think those arguments are weaker. And then the last possibility, and Adam, maybe this is on the merits the most likely one, is for the court to basically say, even on its face, without looking to President Trump's tweets and statements, the national security justification is insufficiently compelling, right, to justify the executive order. I don't think that would convince anyone legally, but it might be a way of saving face doctrinally.
Mm-hmm. All right, here's a more foreign policy oriented question, which I'll send down to the folks on my left. Has Trump's election shown our traditional allies and partners that our political system and civic culture, or lack thereof, is not to be trusted in the long term in terms of promoting common interest, human rights, etc.? What can be done to repair this?
I'll start.
I'll follow.
So I hope not. I think in the short term, yes. I think that what we're seeing is, very quickly is a loss of U.S. credibility on these issues, a loss of any sense of the U.S. as a leader, we really have a situation that where our leadership is completely undermined. I was on a plane the other day with talking to an Austrian who said, was trying to understand what was going on, and he said, we in Europe have had experience with leaders who are just complete lunatics, but it doesn't seem like you in the United States have before. And just the fact that, it was, I think a reasonable point, but also this is the view that now at least many of our allies have about the United States. So I think in the short term, yes, we clearly our credibility clearly on these issues is undermined. I believe in our system. I believe that these can be corrected. I don't think, maybe it's unduly optimistic, but I don't think this is, irreversible. I think if there is a change in leadership, or a change in, I think less likely a change in approach, of this administration, I think that we can get it back, but it's very troubling.
Nick?
It's a difficult question. It's first, one of the odd things about our system is one never knows what one's going to get as president, and probably the only time we ever knew was when George Washington was elected, and everybody trusted him to be the man who filled out Article 2 of the Constitution. The second thing is that one has to remember Winston Churchill's perception and insight about the United States. It tries all the bad alternatives before getting to the right one. And so we are going through a bad patch. I am not going to let the Obama administration off the hook on this. Its credibility with friends and allies wasn't so great either. And I'm not going to go into chapter and verse on it, but I think this administration will learn. I think the president's statement today about NATO is very, very important. It's an example of, I hope, of him learning something about the job. But it is worrisome. And let me just sort of get on my rule of law soapbox for a minute, because I'm a passionate believer in the rule of law and the rule of legal reasoning. It's been a central part of U.S. strategy and foreign policy since the days of Woodrow Wilson. And in a world of nuclear weapons, it is crucially important to remember that international law, for example, is not the answer, but it is a buttress to keeping the nuclear genie in the bottle. Nothing will ruin your day like a nuclear weapon going off. And it dominated U.S. thinking and strategy. Dean Rusk, on his last day in office, closed his briefcase and said, "No nuclear wars on my watch." And that's why we have to be engaged with the world. It's why we have the friends and allies we do. It's why we have vital national interests abroad. And it's why isolationism and America firstism as an isolationist policy is unacceptable.
Can I just make a quick political comment on this, which is, I think it's really important to watch where the congressional Republicans come down on this piece, because a lot of this foreign policy that's being promulgated under the Trump administration is not consistent with traditional Republican ideology on this stuff, whether it comes to promoting democracy and human rights or alliances, et cetera. And I think it's important to watch and see whether Republicans stand up and really push what they believe to be, important foreign policy goals from a conservative perspective, or whether instead you make sort of political compromises on this and say, we're not going to go after the Trump administration on this stuff. The domestic policy agenda is too important. Moving legislation is too important. So I think that's a real key to continue to watch.
I'd like to say that isn't true about the Republican Party. Why was there no congressional resolution about Korea? Truman met with the leadership of the House and Senate and was prepared to submit a resolution. And the leaders said, "We don't need it, we'll support you, and we don't want to listen to any more speeches by Robert Taft." The isolationist, this set of Republicans has reached back to an isolationist tradition in the Republican Party, which hasn't been seen since before Eisenhower. I mean, Eisenhower was the answer to Taft, and Nixon was no isolationist, and Reagan was no isolationist, et cetera. So it's very, very important to remember this. This is kind of a throwback to an earlier part of American political culture that we haven't seen in power in a long time, although the President Obama's interview in The Atlantic is pretty isolationist, pretty worth reading carefully.
I don't disagree that there is an important isolationist strain within the Republican Party. I guess maybe we'll have to agree to disagree as to whether that's the dominant strain among congressional Republicans on the Hill. Certainly when I'm looking at John McCain, Bob Corker, others, they would not consider themselves isolationists.
Absolutely.
And I think it'll be interesting to see how that strain of moderate, thoughtful, foreign policy-oriented Republican responds to some of these decisions that are being made.
Absolutely right.
Just a small point on that, and I agree with that. And I agree that there is a certain amount of influence that Republicans on the Hill can have if they start standing up and disagreeing. But in the area of the conduct of diplomacy, there's not that much they can do other than talk. So it then would depend on whether, even if they do that, is the president and his administration, are they going to, is it going to have an impact? Because there's not a lot, it's a general statement, there's not a lot legislatively that in this area that they can do. I mean, there are some things, but
usually there's the confirmation process, but that would require nominating people to fill all of the open foreign policy and diplomatic posts.
No, but they can hold hearings, both closed and open, and that's the closed-door hearing is a particularly powerful weapon when one wants to pry into the foreign policy of the United States in a granular way.
Next question. This builds on something Rachel talked about a little bit, and maybe I'll add a sub-question to the question. Please describe the state of our nation's national security plan as the alt-right white supremacist extremism strengthens within our borders. Mm-hmm. And what I would add to that is the question of the left decades ago was very protective of hateful speech as a necessary part of First Amendment thinking, even if Nazis wanted to march in Skokie. Are we at a moment in time when we need to rethink approaches to controlling hateful speech?
Oh, well, I'm not going to bite on that one, but what I will say is that I don't know what our nation's plan is in this area, and that's what's so terrifying. I mean, I don't think we have one. I can say that, you know, what I think what CCR has been talking about, what we've been talking about with our allies and with other sort of nonprofits that work directly with impacted communities, with vulnerable communities, with communities of color, is to ensure that we are being responsive to the ways in which those communities are under attack right now, and that, you know, we are recognizing our privilege and using it to ensure that the folks who are really in the target right now can lift up their organize in their communities to fight back against this. Of course, I don't mean fight back with violence. I mean to stand up, to call attention to what is happening across this country, to name it for what it is, right? For the disgusting racism that it is. And to ensure that when there is silence from the government about it, that we are commenting on that silence. So I think it's about sort of partnerships across civil society and nonprofits.
I would just add, I think the plan, such as it is civil rights enforcement by the Justice Department. And I say that with a sigh, because the sigh rhymes with Sessions. Yeah. Right, that historically the principal mechanism for ensuring that hate crimes against whatever group were being meaningfully prosecuted and treated as such and deterred was aggressive enforcement by the Civil Rights Division. Yeah. And I have no faith that we're going to be able to count on that in the years to come.
So here's a question that builds on some things that Mary and Steve said. What is the difference between a leaker who's a criminal and a whistleblower who's a hero? How is this addressed in the Espionage Act or elsewhere? And maybe I would add, ought there be, and Judge Tatel in his concurrence in the Judy Miller case suggested this, some weight attached to the value of the information made public in making these assessments?
Oh, good. So I want to suggest that one can be both a criminal and a hero, right? That I don't think that those categories are mutually exclusive.
Batman.
Indeed. I might even put Edward Snowden into that category, right? That the Espionage Act does not. So let me back up. The Espionage Act makes it a crime to disclose information relating to the national defense to someone who is not authorized to receive it, so long as the discloser knows or has reason to believe that the information could be used to the harm of the United States or the benefit of a foreign power. Period, full stop. Right? So there is no specific intent requirement in the Espionage Act. Right? Courts have never recognized and indeed to have rejected a wrongful classification defense in prosecution under the Espionage Act. The big question, Adam, I think, is whether courts would ever recognize a First Amendment defense to an Espionage Act prosecution in a case where the matter being disclosed was of such surpassing and paramount public concern. But before we get too excited about that prospect, I mean, even in the Pentagon Papers case, where the Supreme Court famously refuses to enjoin the publication of the Pentagon Papers, right? 3 of the concurring justices go out of their way to say, but you could totally prosecute the Washington Post and the New York Times after they've published. So with regard to leakers, I think the reality is that people like, I can't believe this is her name, Reality Winner, commit a very serious federal crime when they leak national security information. I think courts are going to be very resistant and reluctant to recognize some kind of public interest defense. And I think the much more interesting and problematic case would be if the government ever crosses the line from the leaker to the leaky.
Yes, so what you say about Pentagon Papers is of course entirely true, but it's also true that there's not been yet a prosecution of a journalist who was the passive recipient of a leak by someone who had some kind of obligation.
That's right. I mean, there have been two relevant data points. There was one third-party prosecution or attempted prosecution about 10 years ago in the APAC case, which was the first time the government had ever tried to prosecute a recipient of a leak, although
yes,
in that
but
case,
lobbyists, not journalists.
Of course. But we also know that the Obama administration named a journalist as an unindicted co-conspirator in an Espionage Act prosecution.
So we're creeping up to this line.
That's what I'm saying.
And in the Reagan administration, when Bob Woodward published his book, Veil, there were people who were interested in prosecuting everybody in sight, and wiser heads prevailed on the grounds that the Washington Post had far more ink than the Reagan administration.
Just lastly, on the criminal versus hero, I mean, let me sort of take a non-leak example to illustrate the point, right? I mean, if you guys are ever in the unfortunate situation of having to drive a family member or loved one to the hospital, and you come upon a red light, right? We're all going to run the red light. Not because there is a, I'm driving my family member to the hospital exception to the red light statute, but because there are some circumstances where the law is not the most important thing, right? And so, this is where, Edward Snowden revealed details of a number of very important, very secret U.S. intelligence programs, at least one of which was illegal, according to the Second Circuit, right? I think that's a pretty big deal. I think that doesn't mean that he didn't violate the Espionage Act.
No, look, I think you raised Edward Snowden. He should be prosecuted. And the damage he did to the national security of the United States is far greater than any national group coming here, or even the 100,000 people from countries who overstayed their visas back when I was in the government worried about these things. There are leaks and leaks. There's a leak about the Reagan administration deliberations about what to do about the book Veil. There's a leak about the Stuxnet program. That should never have happened, and was a very, very serious leak. There are leaks about by a congressman, and it was expunged from the congressional record, but not from the C-SPAN tape of it, having to do with a certain country fabricating U.S. currency. That's serious stuff.
There are leaks by the president to the Russians of Israeli intelligence information.
So we read.
Very, very serious.
And that fact was promptly leaked.
Indeed.
And very serious.
And I just, on that, I was with you until you used Snowden as an example, because I do think that, there can be, you can be both a criminal and a hero. I think this Snowden, if it had just been 215, if it had just been, then, I think that might be an example of that, because this was a program. The Second Circuit said it was illegal. FISA court says it wasn't. It was approved, but it was a legal analysis that was not intuitive, known to the government. This is an example, I think, of I was in the government when this wasn't, the fact of this wasn't. Of this legal analysis was not released. So I'm blaming myself to some degree that it wasn't. That should have been out there. That should have been. If you've got a legal analysis and it's not intuitive, or really whatever your legal analysis is, that should be out there. So the fact that I'm not sorry, certainly, that the 215 stuff is out there, and I think if it had just been that, I would maybe have a different view about Snowden. But Snowden leaked tremendous amounts of classified information about programs, about just who we collect on and how. To say that is something that needed to be out there is really to say we shouldn't be conducting intelligence. And so I think, so I think because of the huge, tremendous volume of what he leaked that was not related to the 215 or other programs that are controversial. I just can't get on board with Snowden. I'm with Nick. I think he should be prosecuted.
I don't think I said he shouldn't be, right? I just think.
Yeah, but you were talking about him as a hero, and this
Yeah,
is
I
a
don't
man
think he's a hero.
who disclosed sources and methods of intelligence collection that cause irreparable harm because once they're disclosed, they're lost.
I guess, listen,
And
I'm
how we
not.
know things and how we protect the American people is a very serious business.
I mean, so let me go back and say, I'm not sure, I don't think I specifically said Snowden is a hero. I think it is possible to be a hero and a criminal. I agree
And
with
then
that.
you produced Snowden as an example.
That's fine. I mean,
So there, boom.
All right, Steve, walk it back.
Don't walk it back. Don't walk it back.
Listen, I want to be clear, right? I think so. Mary and I probably disagree about exactly how many of Snowden's leaks were in the public interest and how many weren't. I think I heard her say at least one of them was, right? I'd probably draw the number closer to 4 or 5, right? But we can. There are other examples. I mean, the problem here, guys, is not what we think of Edward Snowden or Chelsea Manning or, dare I say, Reality Winner, right? The problem is that the law deals in absolutes in an area where there is a tremendous amount of gray, right? And so I think we're going to have. I mean, as Nick and Mary both, I think there are going to be leaks. Whether Donald Trump is the president, whether that we have the most transparent administration in history, which I think we were told we have right now, right? Like, the question is not. The question is whether there's a way to have some kind of more nuanced, sophisticated legal regime that doesn't just go straight to serious felon.
Here's a question. Can you discuss how Trump's national security / America First foreign policy aligns completely, and completely is underscored twice, aligns completely with his personal financial interests? Should this be highlighted more? Anyone?
It's your job to follow the money.
I would encourage everybody to read the brief that the Department of Justice filed yesterday in the Emoluments Clause litigation regarding President Trump's financial interests. It is a stunning document where the basic argument is it is completely okay that the president receives this much financial interest and consideration from foreign governments with which he is currently conducting foreign policy. I mean, that is basic. I don't think I am unfairly characterizing the bottom line of the brief.
Completely okay is an emoluments clause argument. Maybe
Sorry,
not.
legally and constitutionally. And I think that, and I guess that should, whether that's a correct reading of the Emoluments Clause, or I think more importantly the Foreign Gifts and Declarations Act, is a matter that lawyers are going to be lawyers about. But the policy implications of it, I think, are staggering.
Yeah, and just an example, one of many, but one of the most extreme examples of just the tendency of this president to blow through norms and the kinds of behavior that before would have been just considered completely off, unacceptable, and it seems to mean nothing to him. So it's very troubling.
Steve, do you think those arguments should have come from a private lawyer rather than from the Justice Department?
That's a really good question. I would have been more comfortable with it. I mean, President Trump now has a private attorney, or should I say, Predecessor Trump. Sorry, it's you have to laugh. There is a context, right, where the government will often retain private counsel to represent government officers when they're being sued in their personal capacity. And I understand the argument that where it's the president himself, there's an institutional reason for the Justice Department to be involved. I just wonder if, there's a long-term institutional credibility issue that DOJ being personally and directly involved in this case might raise.
All right, I think we have time for one last question. Again, these are big, broad questions, but maybe this will be a nice way to wrap it up. What are some potential, excuse me, what are some potential safeguards we can put into place to prevent this ideological war on Islam today in America, which is similar to 1933 Nazi Germany? You don't have to accept the premise, but assuming you do, what are the available responses?
I'd like to tell a story
Okay.
about this. I served at the U.S. mission to the UN, and there was a meeting of the ambassadors of the Permanent Five and the French ambassador raised an issue with the Americans, principally, by the organization of the Islamic Conference, the only religious-based organization at the UN. And the concern was that the anti-terrorism policy of the United States had this anti-Islamic flavor to it. And the response of the American ambassador was as follows, that every society has had a problem with people who engage in terrorism. The United States, Japan, Italy, Russia, you name it, China. And every society has reached the conclusion that behavior of that type was intolerable and that there could be no excuses for it. And he said, until the Islamic world so adopts that policy, they're going to have a problem with the identification of Islam and terrorist attacks. It's just a fact. And the French ambassador said, Eureka, and went off to tell the organization of the Islamic Conference. Now, I tell that story not because I approve of the implication, but because it means there has to be conversation about this. There has to be a recognition that it's not an accident that the Belgians don't engage in terrorism, you know. Maybe the Walloons and the Flemish-speaking Belgians engage in a bit of terrorism against each other, I don't know. But we don't worry about the Luxembourgeois. We worry about people who justify the targeting of civilians in order to instill terror, in order to persuade governments to do or not do things. And it's justified in a lot of different ways. And until everybody says it is intolerable in all circumstances, we're going to have a problem.
Yeah, I think I would disagree with that quite a bit. and let me say why. You know, I think part of the big problem we have, not only from a moral perspective, but also from a counterterrorism policy perspective, is this direct linking of Islam, which is by and large a faith of peace, and that brings a lot of solace and community to 1.6 billion people across the world, with terrorism. I mean, if you look at this just logically, right, most of the terrorism that happens in this country is not by Muslims, right? It is disproportionately, look at the FBI's crime statistics. It is disproportionately, frankly, right-wing, anti-government terrorists. And so, yes, if you define terrorism as Islamic terrorism, then you're going to see terrorists as Muslims and Muslims as terrorists. I think one of the really destructive things over the course of the last year was allowing the now president to get away with real anti-Muslim bigotry. Even after 9/11, President Bush at that time, he went and he visited a mosque. He said, we are not at war with Islam. And I think that was a really important statement, even if the underlying policies were disproportionately affecting Muslim men. But I think that statement from the top was important. And I think, with Trump in office making anti-Muslim comments, it's really harmful. With the elevation of Steve Bannon, at the National Security Council, in the White House, it's really problematic because these things do send signals. And I don't think, it's a coincidence that we're seeing, the rise of Islamophobia in this country and anti-Muslim bigotry. I'd also say, we have a project at Human Rights First where we're engaging young veterans, including on this issue of Islamophobia. If you talk to people in the military, they'll tell you this is a real problem for them as well. It hurts us around the world when we are perceived to be acting not in our own national security defense, but specifically out of racism or Islamophobia or bigotry, right? That does compromise our ability to make, alliances with foreign, not only just foreign governments, but also, local populations whose cooperation we do need in the fight against terrorism. So it's unwise, it's disgusting morally, but it's unwise policy as well. And I think, we really ought to focus on this a little bit more.
I know there's more to say, but I'm sorry to say we've run out of time. This has been such a wide-ranging, illuminating, interesting conversation. Please join me in thanking the panel.